You did. I don't know if you saw his Flynn thing. He falsely accused Flynn of treason, and he also said the judge had complete discretion in refusing a motion to dismiss.
Perfect.
Now, I knew the guy was a nitwit.
Let's get into it. Perfect segue. And then before my wife comes in with the kids, Robert. Okay, I don't know if you saw my video. I
did.
Okay, so am I out in left field on any?
No, that's totally right. And I knew at the time the hearing was going on, the judge was trapping him. I was in conversation with some of Flynn's people. I won't get into detail as to how or why, but I said there were serious concerns about the judge after that hearing, watching what took place. Publicly, I said something different. Privately, I said that because at the time there was a chance I was going to represent him at any future proceedings. But it was clear by that point that the judge had a bias against him. Two things were revealed that day. One, the judge clearly was tracking the media's coverage because he made that ridiculous comment about treason. Then he takes a break, but he only goes into chambers. And somehow when he comes back out, he knows that right away to volunteer information about treason. He could only know that because he and his staff were obsessively following Twitter and social media about what he said.
And people are saying, you're an idiot. What are you talking about? We're not at war, and this couldn't possibly be.
Okay. I mean, can you imagine a judge being that long on the bench and being that dumb? That's Sullivan. Dumb as a bale of bricks, not bright.
Okay, now so the one thing I think I knew might be standard protocol in the practice that I'm just not familiar with, when they get someone who's pleading guilty, when they get to someone who's pleading guilty, and they get them to you acknowledge you're pleading guilty to a crime, you're telling the truth, the being satisfied with the services of your attorneys, is that a standard thing to get someone who's pleading to on the record agree to? The
entire thing is a trap to prevent them from being able to set aside the plea for any constitutional reason later. That's what the colloquy is about. So I'll give you my story. Very first time I ever did it, young lawyer, kid lawyer, LA, had a client who really was coerced to plea because of threats to his family to prosecute them. But you're not supposed to talk about any of that, not supposed to say any of that. And the rest. So I get up there. I hadn't been through a plea colloquy. It's my first plea colloquy. And the judge starts going through some stuff, and I'm thinking, okay. And then my client gets agitated. He's like, that's not really true. And I take him out and I say, here's the reality. Unless you say that, the judge won't take the plea. Then you won't get the benefit of the deal. You're better off just saying that, even if it isn't quite true. Maybe I'll throw in some phrases to make it clear for the record. But then the judge demanded, he took it a step further than Sullivan. He demanded, I agree that my client was guilty. And I actually did believe my client was guilty of the crime he had confessed to. It was his best deal. It was his best situation given the circumstances. But I got agitated, at which point the judge got very agitated at me. I was like, do I really need to answer that? And then went along with it because I realized what's in my client's best interest. But I realized what a scam the whole thing is. So everything about a plea colloquy is a scam, in my view. It's not meaningfully meant to get to the true answer. It's meant to say, let's trap you so that you can never challenge this plea again in the future. Asking questions you can't even meaningfully answer at the time.
Well, so that's the other thing. Is like he's asking Flynn to recognize that he is aware of the investigation of FBI misconduct.
Yes,
okay. He acknowledges that. Depending on the outcome of that, like you can't possibly acquiesce or abandon your future rights, not knowing what the outcome of that is going to be. And unless the judge knows, or unless other people know how bad it goes, which is why they're pressing so hard, so repeatedly under oath to confirm under penalty of prosecution for perjury that you're entering this plea, notwithstanding knowledge of a FBI misconduct inquiry, it seems extortive, but I don't know if it's just industry standard.
It's absolute. I always said that all we did is we took the Inquisition and we put a nice fancy phrase on it. And we made everybody feel better about it in the dresses that we wear. But in the end, it is just the Inquisition. You take a duck to the prom, a duck is still a duck. So the old Southern saying, they may have substituted other animals in there, but I'm keeping it kosher. So it's the same nature of it. There's a reason why our system loves confession. And pleas are their favorite form of confession. And it's all about bowing to the king. And it's the same thing that's happening in the streets right now. Submit. Show your shame. Show your humiliation. Show your embarrassment to be who you are. It's that Game of Thrones shame walk kind of thing where the queen has to walk through. So it's that same kind of mindset and mentality. And it's what I hate about it is it's so coercive. It's so punitive. It's so vicious. It's so vindictive. So even when I had clients there was only one client I really, really, really did not like. People can figure that out themselves if they Google certain conversations. But even in that client's case, I hated how mean and vicious the judiciary was and how mean and vicious the whole criminal justice system was. It's the part that's really distorted. And I've tried to soften up some of the lefty types and some of the more pragmatic types to say this system is a barbaric system down deep and does not really reflect our humane values. But it's the nature of it. And because it's the core to power. Our systems of justice are simply about reinforcing power. I always tell people, if you want an honest version of our criminal justice system, just go to Mad Max and Beyond Thunderdome. It's a roll of the dice. It's a spin of the wheel. Yes, indeed it is.
Okay, now I missed the super chat, but SSG Lesser said, what are your suggestions and or advice for a pro se senior such as myself? That it has to be a topic for another day. I did a video about self-representation. I take it for what it's worth, but that would be unfortunately a totally separate discussion, which it might be a very interesting one to have. But so Flynn, so the judge knows there's an FBI misconduct investigation. He says, Flynn, you're pleading guilty. You know that you're never going to come back. You're factoring that in. I'm going to delay your sentencing pending your cooperation with the government as a witness in this Rafikian trial, which is the only reason why Sullivan did not sentence Flynn the day of. It says we want to make sure you cooperate after you've renounced all of these things, renounced the rights that have not yet been born. Cooperate, and then maybe, I can't promise it, but maybe I'll reduce your sentence. And then he gets into discussing treason and all this other stuff.
Yes.
What's the deal there? I don't think anybody knew that Flynn was also, in addition to the threats to his son, was being coerced into testifying in a separate file, in consideration of which he might get a reduced sentence. Do you know the detail on that?
The real backstory is both the defense and the government was shocked by the judge's behavior that day. The government thought, hey, we've got a nice clean rap. Flynn's never going to discover all this bad stuff we did. We got him to plead guilty. We'll be done. We'll be finished. That's the government's goal. Flynn's side has told him you're going to get a straight up probationary sentence. No biggie. Government's recommended it. You're out there. As soon as both sides realized, oh, it's crazy Judge Sullivan day, and he has one of those at least a month, according to people I've talked to that know him, they realized, okay, how do we get him out of this so he doesn't sentence today? The government doesn't want Flynn to say anything about walking back the plea. The defense doesn't want the government to move forward with sentencing. So they went outside during the break, and this is my guess. I don't have personal information on this, but is that they talked to each other. It's what I would have done, and said, hey, let's convince the judge that you really need Flynn for this next case. That way we'll get crazy Sullivan to back off, and we'll figure something out down the road. They never planned on using Flynn for that other case. They never needed it.
I see. Their concern, from what you're describing, their concern is that Sullivan would not have accepted the plea bargain and let Flynn go free. He would have actually sentenced Flynn to jail time, notwithstanding the plea bargain, which would have pissed everybody off and might have caused Flynn to walk back on his guilty plea.
Exactly.
Okay, fascinating. Just going to bring this on. Is Legal Eagle the person who thinks the Flynn prosecution is legit? On topic, police should take this weekend off and let the people see the future. Okay, so then Sullivan then says, above and beyond all this, I'm not going to hide my disdain, my disgust for the crime that you committed. Is that standard? I mean,
no.
Is it standard?
This was one, he showed how thrilled he was to get media coverage. Two, he revealed how much he was following that media coverage in live time. And three, he disclosed not only his complete lack of knowledge about the law, that he had bought into every crazy cookie conspiracy theory version of what Flynn had done, and didn't know basic legal provisions, but that he was very biased against Flynn. And so, and to his credit, he at least let Flynn know that, right? Flynn may have never walked back his plea, but for Sullivan saying, by the way, I'm crazy Judge Sullivan today. And so I'll give Sullivan credit in that sense. But that is extraordinary. Like the Roger Stone judge, she would have hinted none of that. She would have made it sound like, oh, I think you've been very fair. Make sure everything's good. And I want to would have done the same bogus colloquy, but even a little more coercive, would have done no negative rhetoric, would have done no demand he participate in another proceeding, because that can be used against him in that other trial if he was actually a key witness in that trial, and would have made it sound like she was going to go soft on him so that he would be surprised when the knife came in. Sullivan was the opposite way, because he's such a grandstander and natural. He's a natural talk first, think second guy.
Okay, now I'm going to bring up these super chats. Before, the question I want was judicial authority to ask their own questions of their own volition. I'm going to get to that right after these, and then we'll Dapper Dave. Robert, you said your friend gets his cases recused in Texans. Can arguments be made for Sullivan to be recused on future cases based on this conduct?
Very hard. I mean, the case in California against, that's the Manny Real case. He flipped him off. He took a big risk there. But Manny Real was equally crazy, and so that's how that worked. As a whole, it's very hard to get federal judges recused in any circumstance. So outside of it, now, there was a case in Milwaukee I had, early civil rights case. My guy photographed some corrupt cops. They beat him up. The judge helped fix the case, give me a crazy jury, cussed at me, literally cussed at me on the record for bringing up misconduct of police officers on the record to the public with the press watching. He sat there and literally cussed at me for 10 minutes straight. And what turned out good for that is he ended up being assigned to a case I had. He was on a special assignment from Indiana to handle the case in Milwaukee. He ended up being assigned to my case in Milwaukee, and I was like, "You're nuts. You're off. I already filed a complaint against you." And luckily, that ended up being very beneficial to my client. But outside of those circumstances, very hard to get a judge removed from a case.
Okay, interesting. Now, don't say anything, Robert. I'm just going to read the comment. Please say you know for a fact that you know Legal is, and that the SOB is an awful lawyer. Robert Barnes, and I believe he is biased. That is my method of describing it. Robert has expressed himself earlier.
Legal Eagle is an idiot. So there's no doubt. I mean, here it was. He was a corporate lawyer in D.C. for a couple of years. Then he started his own firm, though he's shown up on no case that I know of. It appears to me more the firm is for him to do his YouTube thing. But here's the big giveaway. Aside from the ridiculous Flynn committed treason allegation, when he said that a judge has complete discretion to deny a government's motion to dismiss, that's fake news. That's not real news. It's fake news.
I'm Canadian. I know the Supreme Court. It was Seneningen. I can't pronounce it. Seneningen.
Well, the Seneningen is the amici case, and then there's the direct case, the Ninth Circuit, that even Sullivan admitted when he cited it, called U.S. Blanking on the last name, 2016.
Fokker, but there's Fokker in there as well,
Yes, Fokker is the D.C. Circuit case that said no. And by the way, that's been established law for forever. The executive branch constitutionally controls prosecutions. This is a constitutionally rooted provision that the Federal Rule 48, Federal Criminal Procedure 48, simply codifies and reflects what the Constitution compels. We're not Europe. We do not have judges going around pretending to be prosecutors. This has been established for as long as our republic has existed. And the fact when he didn't know that, not only didn't know that, told people exactly the opposite. He couldn't take 5 seconds to research it. Legal Eagle gets his legal information from CNN. So I'm happy that I found that when I'm looking into it, and I do minimal research online just to make sure I don't make a mistake. But it seemed black and white, and they said the exceptions under which the judge can exercise their discretion are exquisitely limited, and only when they're trying to screw the defendant over.
Okay, Vicky Rosie says, Barnes, at some point, can you tell us, one, if you think Trump is still likely to win, will economy really rebound as quickly, easily per his speech today? Are the unemployment numbers legit?
The Shadow Stats is the site to go to see what real unemployment is. We're probably a little over 20% still. As to the economy, I do not think we'll have a V-shaped recovery. You can follow George Gammon also on YouTube. He's the Viva fry of economics, provides information in an accessible, actionable way that you can digest without being an expert or have a degree to do so. I don't think our economy is going to bounce back real fast. I think we're in further trouble than people think. But the riots have probably saved Trump. If I was an anti-Trump guy, I would totally be into the conspiracy theory about the riots because it will politically rebound tremendously. I mean, we've seen this script before. In 1968, it helped get Richard Nixon elected with ease. I mean, people forget the only reason why Richard Nixon didn't win by a landslide in 1968 was because George Wallace got double-digit support. So, and including in places like Detroit, how did he get, and Milwaukee and Philadelphia, and Newark, how did that happen? The riots. So the riots are going to lead to a massive backlash.
Okay. And there's a comment on the
sad.
riot. And any concern that if the rioters are given what they're asking for, they will only be incentivized for more riots or cause retaliatory riots. I would be skeptical if the rioters are going to get what they're asking for, because I mean they're asking for a lot of different things from a lot of decentralized points, and
only a few lefty cities are giving into this. It'll be interesting to watch. We've been through this experiment, and a lot of your neoliberal Republican types and lefty Democrats and mayors actually tried to give in to a lot of the rioting activities in 67 and 68. All it did was lead to more problematic behavior and then a political backlash in the rest of the country.
All right, next, Fryman, what's something you disagree with Barnes on? I disagreed with Barnes' original assessment in Aubrey. His interpretation of the facts, interpretation of the law, I can't really disagree with, but that's the one that sticks out. And look at that, we're still friends. It's amazing.
And the facts ultimately end up supporting more your assumption about what took place, given that the racial bias clearly was a factor for at least several of them, according to the evidence so far.
I didn't suspect. I didn't go to racial bias. I just said this is not the way.
That something was wrong in their behavior. That their motivation was not reasonable suspicion of a crime.
Yeah, anyways, I took flack for my position from other people as well. But to Sir Barnes, the guy who cussed you out for 10 minutes, any chance we can get a minute order? Now,
it was not in writing, and that's the way these judges do it. They tell the transcript, the court reporter. They'll do this little wave thing, which means no more on the record. Oh, no. And that's when they do all the bogus stuff. And I've been subject to it multiple times. But I push back. It's a weird instinct, so like it's whatever it is. I had a situation. I was walking out with a client. U.S. Marshal FBI agent jumped me and my client, falsely accused me and my client of being involved in a conspiracy to kill a federal prosecutor, all these insane allegations. The whole goal being to destabilize my client's confidence in me, get me out of the case, and punish me for bringing civil rights cases related to him that exposed massive misconduct on the government's behalf in a wide range of contexts. My first response was to just start cussing at him and going right at him. Whatever it is, there's that quiz. They send people, you go into the woods and you come to a tree and you come to a house and you find a cup in the woods and you see a bear and you come to water, and it's all how you interpret it. It has these secret psychological meanings. Well, one of them is you come to a bear, and apparently what kind of bear, what size they are, how they're acting describes your perception of fear, your sense of fear. Well, when I did the quiz, I said I saw a koala bear that you could just go up and hug. So I had no idea. But whatever it is, it's not always healthy for people. That's what I tell my son. It's not always a good idea that I don't have this normal sense of fear in the world, but it has been useful on occasion in dealing with corrupt judges and prosecutors.
That's fantastic. Now, we smoke Bitcoin. Just got to read it. Attention, peoples, buy Bitcoin.
Actually, that's a good idea right now. Things are getting crazy politically and legally. You should be jurisdictionally diversified. Multiple forms of citizenship if you can, but even if you can't afford that, have some Bitcoin so you don't have to depend on the bank stability or any particular currency to be able to survive. If you have some Bitcoin, you can go someplace and get what you need to get by for at least some period of time.
Okay, very interesting. And I'm going to read through these two, then I'm going to ask you the question that I want to about Flynn. Can the lawfare against 2A rights be stopped by removing SI from legislators? What is the SI?
Statutory immunity or sovereign immunity.
Okay, statutory immunity, with the only defense being due diligence that their proposed law was constitutional prior to enactment.
I would love to do that, but what do you think the chances are legislators are going to take away their own immunity? So you'd have to do it by referendum if it's a state, and federally there's no other way to do but go through Congress. So I'm going to try to use whatever happens in the Covington case that I have oral arguments on next week, that if I don't win in the case, I'm going to use to get Congressman Massey and others to push for legislative change to take away Congress members' immunity and use that. So if they were smart, they would make sure Elizabeth Warren lost that case and I won in the Sixth Circuit. Because if not, I'm going to use it to take away all their immunities for everything if I can.
Okay, fascinating, by the way. Now, Martha, my dear, says, Fry and Barnes, love the conversation. Have a great day. Thank you very much. Barnes, this is Robert, this is my question now. Mm-hmm. The whole argument that setting aside, people don't necessarily appreciate it. Sullivan was basically doing nothing more with that brief than giving all of the arguments that he wants Gleason to argue in front of him if it ever gets through him. I'm not wrong about that, right?
That's absolutely the case.
Okay. And it drives me nuts. It's like, it's so deceitful. It's like, I'm not telling you that, but putting all the seeds in his head so that take that brief and argue it in front of me because I appointed you. And if I say no to what you're going to say now, well, that would make me look pretty stupid. But this is the thing. Now, Sullivan's entire argument is predicated on the fact that No one's arguing the adverse position because now the Department of Justice and Flynn are aligned. So I need somebody to argue the adverse position. And now I forget who I had the argument with, but in Canadian law, judges can ask any question they want of their own volition. They can conduct basically whatever inquiry they want of their own volition. So
Yes.
my understanding under Canadian law, that whole argument is absolute nonsense. Sullivan could ask every single one of those questions that he raised in his brief in the absence of an amicus. Is that the same in the U.S.?
Of course, absolutely, and they do it all the time. He's given four law clerks, highly qualified law graduate law clerks from the top law schools, graduate at the top of the class, to do that legal research for him. So what he really wanted was political cover. He wanted somebody else to be able to talk to the press, to leak certain information, to do independent investigations, things that he could not practically do. But it made zero sense, him saying, yes, I'm a federally appointed judge. Yes, I'm given a staff of 4 law clerks. But golly gee, I just don't know how to research the law when both sides are on the same side. He does it every single day. That's his job. That's what he gets a check for.
And I'm also not mistaken that I presume he knows he has the authority to do it from the bench, but if he does it from the bench, it's at the hearing on the motion, and it doesn't add another 4 months of delay that the schedule he set up for the amicus would incur. Possibly, maybe it's one of the reasons bringing this past November.
Correct. He wanted someone to argue to the press. He wanted someone that could ask for subpoenas. That's his main objective. And to some degree, because he's not bright, he did want someone that was maybe more skilled than him to make the argument than he thought he or his clerks could make. The problem is with his law clerks, I've long argued to federal judges, you can hire 2 young kids, but go out and hire 2 long-standing lawyers to also be your law clerks that have seen real world, because they'll give you better balanced information about how to interpret both the law and to interpret what's happening in court when you need that additional contribution. He doesn't have that. So he has 4 kids and himself. To his credit, he knows he's not the brightest bulb on the block, and he doesn't trust his clerks to know how to weasel his way out of what he wants to get into. But that wasn't his primary objective. What people didn't realize, his primary objective is, as a judge, he cannot leak to the press. A counsel that he hires on his behalf can leak to the press. So they can talk to the press, they can plant stories in the press, and so on and so forth. That's what he's trying to do, in my view.
Okay, it's phenomenal. Now, I'm going to say that Tailix001, I think I missed your super chat. Ask the question again. Don't put it in the super chat so I can get to it. My apologies. It's Real Bambunga says, wouldn't giving him well-educated clerks be an obvious pathway to partisan decisions? Why not provide him with 4? Okay. I knew it was going to be a joke by the end of it, Bambunga.
There's some chimpanzees that could write some better opinions than I've seen some clerks write in the last 10 years. I'll put it that way.
What do you think of my prediction? What do you think the Court of Appeal is going to do? Are they going to?
It's all about the panel. There's only one Obama judge. The one Obama judge will rule in Sullivan's favor. The key is the Trump judge will rule in Trump's favor. The old school Reagan judge, he's going to rule in Flynn's favor. I shouldn't say Trump's favor, Flynn's favor. So I think it will be a 2-1 decision. Issuing the writ as requested.
Issuing the writ, not referring it back so that Sullivan adjudicates on the DOJ's motion to dismiss.
They're not going to tolerate that. It sets too bad a precedent. Particularly, I think it offended the old Reagan judge. My guess is he writes the opinion, and his point is, hey, judges, don't be thinking about doing this nonsense in the future. We're going to publicly slap you when you do, so that you're sufficiently embarrassed to think, okay, I'm not going to try that tactic again.
Okay, did I miss anything? Robert, did I miss anything with the Sullivan? I mean, it's.
Just legal is fake news.
The problem is I was going to do a response to legal on one of the Flynn stories, but I don't want to look like at some point I feel guilty. I don't want to look like I'm just trying to ostracize him. But I watch it. And it's like it's not just spin. It's misinformation in a way that is. My biggest concern is just being wrong on the internet, because you can't take it away. And if it's an unforgivable mistake. Unforgivable in the sense, like, a negligent mistake, it's a problem. But I'm reading this and I read through it, and it's like, where am I making a mistake here? This is terrible. The one thing I forgot to mention, 2 things actually, is that the attorney that Sullivan appointed is in fact paid for by taxpayer dollars. It appointed under some provision of law that I wasn't sure what it was. And then the other thing was that Sullivan's attorney is the attorney representing Cheryl Mills.
Yeah. It's a close world after all. So there's no question. I've still never seen a judge appoint a lawyer in that situation. So I get that there's a statute somewhere that allows certain aspects of it, but it's in my view not being properly applied in this context. I've never seen a judge do this. I've seen judges assign lawyers. If I'm a member of a court, I'll get some judges who like to screw with me by trying to assign me some terrible case. So like, hey, you could do this case. Usually I find a Boston legal way out of it. People want to watch Boston Legal to figure out what I mean. But I've still never seen anything like what this judge did. But what Legal is doing, he's heavily promoted by YouTube. Every time I log on, they are bombarding me with his videos, and they've been doing this now for a year and plus. When I watched him, I was like, first of all, I've never heard of this guy. And then I watched him like, this is not informed analysis. This is like a knockoff CNN legal analyst who went to law school, never practiced law. Now, it looks like he's practiced a little bit. I'd emphasize a little bit in terms of real practice in the real world. But when he made the basic, there was the crying thing with Adam Schiff. So the closing argument is so moving. I was like, I mean, come on, even lefties can't even do that with a straight face. And then it was one after the other. Like he was very aggressive with Tulsi Gabbard's suit, but then very protective of Democratic suits. I was like, okay, this is just political analysis that has almost no substantive legal analysis. About half the time it will have at least some of what you could find on a Google, but half the time it's just bad analysis. And then the Flynn analysis was atrocious because he suggested towards the end of this video that Flynn committed treason, which is literally ludicrous if you understand the law of treason. I tell my friends on the right that when they're like, hey, let's bring Obama treason or Hillary Clinton. It's like treason can only happen when we're in a war or we have to have declared actual war against them. Otherwise, treason is not illegal. And for very good First Amendment reasons, we keep it that way. But when he said that at the end, I was like, that's just a ludicrous allegation. And when he made the statement about, he's got complete carte blanche to do what he wants. It's like, that's just false. That's false news. That's fake news.
No, and people are gonna come out and thinking he's the judge, he gets to decide, and he had good reasons. There were no adverse positions, so he appointed his own prosecutor. I mean, it's exactly usurping the role of the executive branch.
And YouTube is promoting it. Google is promoting it. So my views are promoting. I didn't care as much until I saw how much they're promoting, and he's getting millions of views of some. Like he has this whole thing about Lafayette Park is the sign of a banana republic, a tin cup dictatorship. It's the deprivation of all rights and liberties. Watch that lawsuit the ACLU brought. They're going to lose that suit. The allegations there are totally weak and not with that merit. And aside from the cry fest that he did, I'm like, this is just purely partisan political news, which I don't mind that as long as you have legal substantive analysis behind it. I disagree with Dershowitz on the constitutionality of forced vaccines, but he'll give you a detailed, logical, legal analysis as to why, and I respect his mind tremendously. It's just that he's just pure fake news. He's a guy that's just going to spread fake stories that push a narrative, and people think it's actually high-quality legal analysis.